All right, we're going to go ahead and start the session. I'd like to, and it is my pleasure, to introduce this panel. They are from my neck of the woods, the Northwest. They're from Seattle primarily. The first one I'd like to introduce is the Honorable Michael Trickey. Judge Trickey is on the Division I of the Washington State Court of Appeals, and he was appointed to that position fairly recently in May of this year. Before that time, Judge Trickey served on the King County Superior Court, and that's primarily Seattle, from 1996 to 2014. He was presiding judge in 2006 to 7, and he has worked on the, and he was presiding judge of the statewide Superior Court Judges Association. Judge Trickey is the man in the middle. Next to him is Paul Sherfey. Mr. Sherfey has both private and public sector experience. Paul is currently the director of the Judicial Administration and county clerk in King County, again, Seattle area. Paul serves on the board of directors for the National Conference of the Metropolitan Courts as well. And our third presenter today is Mr. Stephen Crossland. He's been practicing law for over 40 years, doesn't look a day over 30. He has chaired the Limited Legal License Technician Board. That is something new in the state of Washington, beginning in December of 2012. He was president of the Washington State Bar Association, and he has received the Award of Merit from the Washington State Bar Association. So those are your three panelists today. I would ask a couple of things of you. This is being photographed. Further information about their bios is on the website. Since it's a taped session, I'm going to try and run around and catch any questions. I've been in a couple sessions where it's hard to hear, so I'll be dashing around to make sure we hear all of your questions as well as our panelists here. You'll be receiving an evaluation. You probably know that by now. So without further ado, gentlemen. Thank you.
Thank you very much, and thank you for allowing me to come and speak with you today. I'm going to give you a little bit of background and history about how we developed this rule in the state of Washington and why we developed the rule in the state of Washington. I'm going to give you a little bit about what the rule actually does, what some of the elements of it are, and how it's intended to work in the marketplace. And then I'm going to have Paul and Judge Trickey follow me, and then we're going to leave at least, I think, 15 minutes for questions at the end, because we really want to have you have the opportunity to engage with us and us with you. There are going to be a couple of themes that I think you'll hear throughout my portion of the presentation, and they're really kind of the underlying reasons why we in the state of Washington adopted this this rule. And they're really consumer protection and access to justice. The other thing that you'll learn after this brief presentation is this just didn't happen yesterday. This has taken quite a long time, somewhere between 10 and 12 years, depending on where you mark the starting point. This started really with us in the process of trying to engage with the consumer protection component, in other words, the unauthorized practice of law, and the idea of serving and protecting the public. So in Washington, after many, many, many years of studying the issue of unauthorized practice of law, we learned that the real starting point for dealing with the issue had to be with creating a definition of the practice of law. And so we put together a committee and came up with the definition that we proposed to the Supreme Court. And as you can see from this slide, we created GR 24. The court adopted GR 24 in 2001. And really it was sort of the bright line to the public and to all practitioners of what lawyers are authorized to do in the state of Washington. The court at that point said, that's great, but how in reality is that going to work in the real world? In other words, how is this going to affect access to justice and the consumer protection component that we've been talking about? So the committee went back to work, worked another year or so, and came back with what they proposed to the Supreme Court as being GR 25. And GR 25 did several things. One, it created a body called the Practice Law Board, and the court empowered them to then field complaints that were or were not the unauthorized practice of law. They could issue advisory opinions. But the more important part for today's discussion that the Supreme Court did is they delegated to the Practice Law Board the recommendation that the Practice Law Board come back to the Supreme Court with a proposed rule that would authorize non-lawyers to engage in the limited practice of law. And that was for the purposes of meeting the unmet civil legal need, the access to justice problem. So about the same time, we all in Washington, and I'm sure all of you all over the country, know there is an access to justice problem. There's a huge unmet civil legal need. But our Supreme Court had the wisdom to commission a civil legal needs study. In other words, they wanted to quantify this. They didn't want it just to be conjecture on the part of citizens. So they about the same time they were creating GR 24 and 25, commissioned the civil legal needs study. And I'm not going to go through all the details here, but I'm sure you all know the litany. In our state, more than 85% of the poor and working middle-class people do not have their civil legal needs met. Our Supreme Court Justice, in a keynote talk that she gave several months ago, quantified that in Washington to be about 1.2 million people each year can't access the legal system because they can't afford lawyers. So that emboldened the Supreme Court even more to ask the Practice Law Board to come back with a proposed rule. We, on the Practice Law Board, worked on this for about 2 years. We looked around the country to begin with and said, is there a model that we can copy that we can just sort of implement here in the state of Washington? And really found nothing that was quite to the degree that we felt our Supreme Court was wanting to see in terms of recommendation. We went around the state and we sought input from stakeholders in many, many groups from all over the corners of the state. And we got to remember, we were a board created by the state Supreme Court, not by the State Bar Association. But in an effort of transparency and for this process to work, we felt it was very important to engage not only the court, but who commissioned this, but also the Washington State Bar Association. We submitted the rule to both simultaneously and made a presentation to each. We went first to the Washington State Bar Association Board of Governors and made a presentation, and I would say it's safe to say they were not amused. The vote on that go-around was 13-1, and had one friend in the audience somewhere. Undaunted, we followed our charge and went to the Supreme Court and said, here we are, here's the rule, this is our best shot at this point. And they said, well, go back to work, go back to the drawing board. Again, just like with GR 24 and 25, they said, well, why don't you tell us how this is actually going to work in the real world? Why don't you apply it or recommend that it be applied to a particular practice area? And let's kind of see how that looks and feels. So we went back to work. And we thought, well, let's take a look at what practice areas should it apply to. And we looked at the civil legal needs study and found that there were 4 areas that seemed to have significantly high areas of need. They were immigration, landlord-tenant, elder law, and family law. And we thought, we as a board really don't know much about these practice areas. Why don't we invite experts in these particular practice areas and ask them a couple of questions. One, is this an area that the scope of delivery of services could be limited in a way that it would provide assistance to those unmet civil legal need consumers? Number one. And number two, if they provided that service but didn't do it adequately, would the harm be significant? And again, serving and protecting the public was sort of the mantra for this process. These subcommittees of experts came back, and 3 of the 4 said, yeah, we think that this rule could be applied to these 3 practice areas, but the 4th area, immigration, the subcommittee came back and said, first of all, there's the federal preemption issue, and secondly, and maybe more importantly, the consequences if they make a mistake may be dire. They may be deported, which wouldn't really be remediable in any easy way. So we, armed with that information, we proposed to the next go round to the Board of Governors, State Supreme Court, that the rule initially be applied to the area of family law. Of course, you might imagine the family law section didn't think that was very amusing either. But we nonetheless presented to the Board of Governors. We made a little progress. The vote this time was 12-2, not 13-1. We went on to the State Supreme Court. I'm starting to feel like Sisyphus at this point. That we dutifully reported back to the Supreme Court and said, here it is. Here's the area we think it ought to be applied to. And about the same time, our Supreme Court was adopting and rolling out, and the Bar Association was rolling out the Moderate Means Program, which was a program that was designed to help deliver legal services at a lower cost to people who couldn't afford full fare with lawyers. And I think the Supreme Court, again, very much wanting to see the access to justice problem dealt with, said, well, let's kind of wait, and two things, let the fire simmer down a little bit, and secondly, let's see how the Moderate Means Program works and see if it's going to be of any significance in assisting this problem. The Supreme Court put it out for public comment and got both favorable and critical comment, and then they decided that they would just kind of sit on it, which they did for about 2 years. In the fall of 2011, the Supreme Court indicated they were ready to vote, up or down. They didn't tell us which direction, but they said, need to get ready. And so the Bar Association, anticipating that this responsibility of regulating this program would be delegated to them, the administration at the Bar Association said, we need to do some technical amendments to the rules so it's more easy to administer. It was created by the Practice Law Board, who had no experience at all in creating such a rule. So those rules and those amendments were sent to the Supreme Court, and then finally in June of 2012, the Supreme Court voted, and they voted by a vote of 6-3 to adopt the proposed rule. And I'm going to read to you part of this. This is Chief Justice Madsen wrote the order, and I'm going to read part of it because it embodies what I told you at the outset, which was access to justice and consumer protection. Part of the order included this language. We have a duty to ensure the public can access affordable legal and law-related services and that they are not left to fall prey to the perils of the unregulated marketplace. So Supreme Court adopted the rule. Part of the rule was it created a board. And you could, I should stop here and beg and beseech you to give us a new name. The limited licensed legal technician is quite a mouthful. We've decided to call it the LLLT, which only is slightly better in my mind, but it's better than the whole mouthful of limited licensed legal technician. And nonetheless, the court created the LLLT board, 13 members, 4 of whom must be non-lawyers, 1 of whom must be a legal educator, and asked this board to implement the rule. And one of the criticisms as we were going through this process of proposing this rule to the court was, gee, it sounds to me like you're trying to create a whole nother bar association. And at first I was a little defensive about that, and then I went, you know what, that's exactly right. That's exactly right. We are going to create a whole new bar association because we think, as you'll see in a few minutes in terms of the requirements and restrictions, we want the public to be served and protected. And I'm going to continue to say that throughout this talk. One of the first things we were asked to do was to pick a practice area. Before we got to that, I sat down with the Chief Justice and said, when would you like this rule implemented? And she said, well, sooner than later. And I thought, well, that's going to be interesting to roll out this whole thing in sooner than later. But I have to tell you, and I'm going to compliment the court and the board a couple of times during this talk, our board is an amazing board. They all have day jobs, and they have worked incredibly diligently over the last 18 months to implement this rule, and I'll give you a little flavor of how we did that. But we meet once a full day, once a month, and then in between we have subcommittee work. But they're just an amazing, amazing group of people. And again, I want to compliment the court for taking a 6-3 vote in a controversial rule that was certainly not favorable with lawyers. I have to tell you, though, since that time, I think the concern and anguish on the part of lawyers has diminished greatly. I think they now say, you know, this is the law of the land. The court has adopted this, adopted for good reasons, articulated by the Chief Justice. and now let's implement it. And I'll talk, I have a little incident that I'll relate in a few moments. So we recommended the Supreme Court that family law be the first practice area. The Supreme Court adopted that, and frankly, if you're, I don't know if it's among my materials, but the Chief Justice's order sent a pretty direct message, I think, that family law was the area that the court felt would be the first area that would be appropriate to apply the rule. The process we followed is we decided we can't swallow this in one bite, so we divided the work up into 5 subcommittees, and we picked 2 subcommittees at the beginning. One of them was to define the scope. We picked practice area. This is a limited license. How are we going to limit the scope of what these people are authorized to do, and so that they know what they're supposed to do? And then second, the second subcommittee was to create an education program to teach to that scope so that the people are well-trained and qualified to deliver the services that have been approved by the state Supreme Court. Both of those processes were incredibly dynamic. With regard to the scope, we again brought in experts in the area of family law and said, tell us everything that family law lawyers could do. And then let's pick it apart and decide exactly what they do. And then within each of those delivery of service areas, let's talk about what a person could be authorized to do that would, again, serve and protect the public. So once that was approved by the state Supreme Court, then the Education Committee got together and devised an education program that, in their minds, would qualify these people to deliver these services. This was really a surprising and amazing part of the process because it brought together connections and collaborations that I really hadn't even imagined would happen. First of all, part of the rule says that the practice area classes must be, the curriculum must be created by ABA-approved law schools. So we got the ABA-approved law schools, of which there are 3 in the state of Washington, together and said, here's the project, can you help us? And all 3 of them came with open arms and said we'd be delighted to help, sat down with us and said, this is what you can authorize them to do. These are the kind of classes that we think you ought to be delivering to these people so that they're qualified. So that's the practice area portion of the education. The core component really somewhat mirrored some paralegal programs that were in the state, but we created our own criteria that was different than most paralegal programs in the state. But again, the community colleges stepped forward and they said, if that's how you want to do it, we're happy to change our curriculum to meet your requirements. And so the collaboration within the community college system, there are 29 in the state of Washington, and collaboration within the law schools, and then the collaboration between the 2 was just a dream come true. I couldn't have imagined that it would happen that way. One of the comments by one of the law professors, well, let me back up. On the practice area education, it's co-taught by a professor and then an adjunct professor. And so they're getting both practical and academic sort of part of the education. One of the other delightful things in this process, and sort of served as kind of a touchstone for us as a board, we were trying to make decisions about what was appropriate for our program, was we adopted what we called the 3 A's. We wanted this program to be affordable. In other words, if it was so expensive, students wouldn't be able to go out and make a living. I mean, that's part of the difficulty that law grads are now facing. And so we wanted to make sure we avoided that landmine. And in that respect, again, wonderful collaboration. We figured that the total cost of LLLT from beginning to end is something less than $15,000. Part of that is 3/4 of law school education, and the law schools have agreed to market those hours at considerably less than what a law student would have to pay. It's less than half of what law students would have to pay for the same or similar classes. So again, A, it's affordable. 2, we wanted the program to be accessible. We figured that LLLTs may want to be educated in all parts of the state. The access to justice problem is throughout the state. And so we wanted to make sure that we were utilizing the resources of all three law schools and all 29 community colleges. The college, as I mentioned before, the community colleges have stepped up, and one of the things in terms of accessible that we have hit upon with the law schools is that the classes these first year have not been taught live, but they've been streamed live throughout the state. So the students can get online, interact real time with the professors and with one another, and it seems to have been working well. Our ultimate goal is to teach them both live and stream them so that they're both affordable and accessible, both real-time in person and real-time online. And then the third component was we wanted this to be academically rigorous. And that's why, again, the collaboration between the community colleges and law schools was just a godsend, because I think having these students have a full year of classes through the law school really lends them credibility. The second two, we completed that work about 6 or 7 months ago. The next two subcommittees that we undertook were creating an examination and creating rules of professional conduct. APR 28, the rule authorizing LLLTs. I mentioned this looks like a bar association, and they are subject to pretty much the same rules of professional conduct. They're subject to discipline. They have to have continuing education, and I'll go through some of the other requirements in a moment. But so we've worked really, really diligently. We have a former president of the state bar who was head of Ethics 2000, who chaired the RPC subcommittee and has done an incredibly marvelous job of taking a huge body of information and adapting it to our rule. I'll go through some of these. This next phase is sort of the requirements, the education requirements. I've hit upon some of that, but I want to give time for the other two speakers and for the rest of you to ask questions. And I'm not sure how much time we're in.
We've been going about 19 minutes.
Okay.
It's 7 after.
Perfect. Okay. Then I'll go about 10 more. Okay. These are the minimum requirements. I'm not going to read them to you. You can read them. But one of the interesting requirements is about halfway down. It says, show proof of financial responsibility. I think only one state in the United States has mandatory malpractice insurance, and I think that's Oregon. Certainly Washington does not. And the court was actually a little curious. They said, well, why is this in here? And we said, you know, we are taking very seriously the mission of serving and protecting the public. And we feel that if we are going to protect the public, there needs to be some recourse if the LLLTs don't live up to the standard that's expected of them and cause some harm. I don't know if that's going to spur some change by our Supreme Court to look at that requirement for lawyers at some time in the future. It might. These are some of the things that LLLTs can do. And again, I'm not going to read these to you, but I will give you the sense of what these are. The rule in a larger sense is really designed to assist what are now pro se clients. They're not clients who are going to, in our state, NJP or are under a means test for delivery of service. But these are people who just frankly can't afford full fare for lawyers. And so the idea is to assist a pro se in a way that is meaningful, to assist them to get through the process, and to assist the court in allowing these people to navigate through the system and get to the conclusion that they're anticipating. These are three things that under APR 28 they cannot do. They cannot represent a person in client in court. They cannot negotiate on the client's behalf, and they cannot communicate with another person in the client's position. Having said that, and we talked, the other panelists and I talked about this before this program, we've had recent discussions on our board and recent discussions between our board and the state Supreme Court. And we are going to relook at items 1 and 2, whether they should appear in court and whether or not they should negotiate on behalf of a client. As we've been rolling out the rule and giving talks around the country and thinking about how this rule actually plays in the real world, we've come to the conclusion that perhaps it would be better for the courts, better for the clients, if LLLT's authority could be expanded in some way so that they could at least appear in court, not be advocates in court, not arguing the case as Clarence Darrow might or Perry Mason, but simply be able to there to a further and to a greater degree assist the clients as they navigate through the system. So that's a discussion our board's going to take up in September. Our first LLT may be licensed by next spring, so we're hopeful that if that change is going to occur, that the Supreme Court will act somewhat quickly. It may implicate the education component, but we're ready for that. We figure if this is a tweak that we need to make, it's better to make it sooner than later. This is kind of a schematic of what we think lawyers do. The upper two quadrants, advice and counsel, are really what, on the higher level, we as lawyers are trained to do. We also get involved in content and process, but those are things that are really things that perhaps we should be delegating to other things that could be done for less cost and more efficiently. And that's kind of those are the quadrants that we envision LLTs being most useful in. How are we doing?
Yeah, about 7 minutes.
Oh, great. Okay. This is the scope of family law. And I want to stop here for a moment and make sure everyone understands. This rule was designed to meet unmet legal needs. We picked family law as the first area to which we would apply the rule, but we would contemplate making recommendations of other practice areas in the near future. And but for the discussion that we're having in September, I think we would have embarked on that discussion about additional practice areas in September, but we'll probably do that in October or November. So these are the things that our subcommittee, the experts who were drawn together, said this is what they do and this is how we would authorize non-lawyers to engage and make deliver legal services in this limited way. The admission requirements, I mentioned that they have core requirements and then they have practice area education requirements. They actually will end up having to take 2 exams. They'll take an exam for the core area education, and then they'll take an exam for the practice area. As additional practice areas are rolled out, if LLTs want to be authorized or licensed into additional practice areas, they can take the practice area exam in those additional practice areas. They would not need to retake the core. I forgot one. One of the other things that we thought in step 3 that we thought was important, over my years in the practice, I've heard a lot about mentorship programs and apprenticeships, and we should be better practice ready when we enter the practice. And we thought it would be really helpful if LLTs, in order to better prepare them to serve the public, that it would be wise and helpful for them to serve or to work with under a licensed attorney for 3,000 hours. They can do that anytime before, within 3 years prior to taking the exam, or they can do it within 3 years after the exam. I think most of them will be doing it simultaneously while they're taking the core and practice area education. They'll probably simultaneously be attempting to get their 3,000 hours. Again, I'm not going to read these, but this is part of the curriculum that we devised for the core education. I mentioned that we wanted the 29 community colleges and we wanted this program to be accessible. One of the things that we're also reviewing is the rule said that the core classes would need to be taken at an ABA-approved community college program. I mentioned 29 schools. There are 5 ABA-approved paralegal programs in the state. And we were looking at that and saying, you know, I don't know that that allows this program to be accessible in a way that we hoped. So we're bringing together all of these constituents, people involved in academia and the community college programs and the paralegal programs, and are beginning to devise our own standard, not the ABA standard, but our own standard for the LLT program, in hopes that it will expand the opportunities for people who are interested in the LLT program throughout the state to be able to get the education in an area that's more accessible. I think I've talked about the practice area education and the family law courses. Again, the family law courses were devised completely by professors from all 3 law schools. It's been a delight to, I've sat in on some of the classes and to watch them engage with the students, and then the students are so incredibly enthusiastic. This slide is just sort of a snapshot of what I've referred to several times about the diversity and geographical diversity of the community college programs in the state. And as you can see, any of you who are familiar with Washington, the population is in the Puget Sound area. And so that's where the largest concentration of community college programs are. But again, as I mentioned before, we need to make this program accessible, and therefore are trying to spread the programs throughout the whole state. In order to get students in, we realized that we have an abundance of people who have been paralegals working and probably are incredibly qualified, probably better qualified sometimes than the lawyers for whom they're working. And so we decided that, we would allow them to trade their experience for the core education component. They have to, though, have passed a national exam certifying them as a paralegal, and then they still have to take the practice area test and take the core test really for the whole program. So all this does is allows them to be able to take the family law practice area education. We've got 17 in the program this year, and I think about 12 of them are there under waiver. So let me stop at this point and turn it over to Judge Trickey, and then we'll open it up after both have spoken for questions. Judge?
All right, can everybody hear me? Well, thanks, Steve. First of all, I just, quite honestly, before I was invited to be on this panel, I knew almost nothing about legal LLLTs. I had been asked when I was still on the trial bench to go out to a community college in Edmonds, which is north of Seattle, and address them of topics of interest. And one of the ones that came up was this LLLT program. So I started going online and researching and everything else, and I was impressed at the amount of effort that both the Supreme Court and the State Bar, and in particular Steve, has put into this with the rigor, with the training and the regulatory structure that they've tried to put up. But what I was really impressed by was when I went out and talked to this class of people who are training to be paralegals, they were really excited about this. They see this as sort of a transformative moment because it comes at a time when, and I know everybody in this room works in the court system, so you all know this, there's a huge crisis in our courts, not only access to justice, but on the legal profession in general. And on the access to justice issue, it's really across the board. You can't hardly open a paper or watch a news show without talking about the funding of public defense, the funding of attorneys in general, and then the legal profession. I mean, law schools are actually declining in enrollment, and this is because of the enormous expense it takes to become an attorney, the limited job opportunities that are available now in post-Great Recession America, and yet the need is never greater, as the civil needs study showed. So this really comes at a time, and I saw it continually as a trial judge. I was a trial judge for almost 18 years in King County. It is the most populous county in the state of Washington. Besides being court administration, I served on a number of calendars. One of our calendars is Unified Family Court in King County, and so I spent a year and a half just trying family law cases, and after that, just taking family law cases on assignment when I was on other trial calendars. And Washington State, like the rest of the country, not only has an enormous number of self-represented persons, it also has people who are not native English speakers. And so I can't tell you how many dissolution cases I tried where both parties are there, neither one has an attorney, neither one speaks English. The court has provided at public expense interpreters for both these parties, and I would spend 2 or 3 days trying a case that at the end of those 2 or 3 days, I was convinced if they'd only been able to talk to each other, we'd be able to facilitate something ahead of time, we could have saved ourselves a trial, we could have saved the interpreter costs, and I could have been trying some other case. So this comes at a time, and I think that's why the Supreme Court reacted as it did. I think it's totally appropriate that the first focus is on family law. Again, I think Paul knows the statistics much better than I, but I think it's 85% of the cases in King County where at least one of the parties was representing themselves at some point in the proceedings. So this is not a case where these cases are being taken away from the bar. These folks just can't afford lawyers. So it's either they're going to have they're either going to represent themselves, or maybe they'll have a limited legal license technician helping them out. There is this Civil Gideon effort, as I mentioned, going around the country, but I just don't think we'll ever have enough funding to pay for lawyers for everyone. It's just, unless we have a dramatic reallocation of resources into the court systems, it's just not going to happen. So there has to be some sort of steps that are being made to do that. Another reason why I thought it was appropriate to focus on family law was, and I don't know how it is in other states, but in Washington, the family law practice has become intensely form-driven. The state, through the Supreme Court and also through the legislature, creates creates mandatory forms that everyone has to use. And so it's a huge burden for everyone just to prepare the forms to get to a point where you can discuss how trying to resolve the case without actually going to trial. I mean, when I was in private practice, I used to handle family law matters back in the 20th century, as I like to say. And in those days, in the early 80s when I was doing it, you could do a 2 or 3 page dissolution decree. In that dissolution decree, you'd have one sentence that would, and it almost always said this: mother shall have custody of the child, father shall have reasonable visitation, child support is set at $150 a month. So those 3 sentences, each of those sentences has now been converted into a 10 to 14 page form that has made it so complex. The judges struggle with it, the attorneys struggle with it, and in particular, the self-represented litigants struggle with it. So to the extent that these LLLTs can help these folks go through the system and then just get into court, it's not easy just to note a motion or argue a motion, all that stuff. So this is an interesting approach to this. A couple of 3 issues that I saw that I think are going to have to be worked on is, how is it going to work when the case actually gets to the court? I can see the LLLTs preparing the forms, giving them to the party, and maybe if they agree, they can enter it, and it's all well and good. But lots of these cases end up on what we called in King County the family law motion calendar, where people couldn't agree on child support or temporary custody, whatever. They would argue it out, and I can see litigants showing up with the paper, and the judicial officer, either a court commissioner or a judge in some cases in King County, would say, well, I don't think child support should be $700 a month. I think it should be $650 a month, and so I can't sign your order. Can you modify it? And then the question is, how do you do that? I mean, is the LLLT going to be there at court? Could it be modified? Paul can talk about the ways that King County has sort of dealt with this, but I think in the end that's going to be one of the big issues, in court or not. Are they just going to be, and I don't mean this in a demeaning way, are they just going to be document preparers, or are they going to be something more? I think that's one of the long-term issues. The second issue there is ethical issues. We were talking about this at lunch today. You know, a lawyer can't talk to a represented litigant. That's a huge ethical issue. Can the lawyer talk to the litigant who has a LLLT? As I understand the current rules, the LLLT can't negotiate on behalf of the party. So, and I think Steve pointed out there's a whole group of the board that's working on the ethical issues of that, and judges are going to be really conscious of that, because quite frankly, I was seeing a lot of people who were holding themselves out as paralegals. And this goes to the consumer protection piece that he talked about. You know, I'm a paralegal, I'm here to help. Well, what does that mean? You know, and so this is a very regulated program that seems to have a tremendous amount of credibility. The third piece is, and this only occurred to me after lunch, is the Supreme Court has been really involved in this process. The Bar Association has been really involved in this process. The trial court's not so much. And so as this rolls out in 2015, there's going to have to be a way to reach out to the trial court and educate them, because I can just see them showing up and say, hi, I'm Jane Doe, I'm a LLLT, you know, and everybody's going to go, well, I don't even know what that is. So those are just my brief comments.
I have to say that when I first heard about this several years ago, and I told Steve I was going to mention this, I had my attorney hat on, and I was quite concerned about it. In law school, you were taught that if you are given a family law case, you better also have attended tax class and property class, etc., so you understand the nuances, that something you might do on a family law case could affect their tax situation, their long-term benefits, retirements, et cetera. And so I was quite concerned about the quality of education these individuals might receive, concerned about how they would be regulated or policed. And at a very selfish level, I was concerned about my peers having $100,000 debt from law school and then competing with these individuals. I have, though, after hearing Steve on more than one occasion explain this program, become quite optimistic about what this can do for court administration. A little bit about our county. We, as Judge Trickey mentioned, we have about 85% of all of our family law litigants are self-represented at some time along the way. And also, as Judge Trickey mentioned, the need for interpreters is very great. We're now up to 144 languages in King County, and so we spend over $1 million a year on interpreter services. And so the complexity, particularly in the family law area, becomes, it kind of suggests you have to have as many options as you can to help people through the system. We're very lucky in Washington State because of a court rule passed many years ago, GR 27, we have what are called facilitators. And those individuals, sometimes they're placed in the clerk's office, sometimes in court administration, and about 20% of the time the counties and the courts contract with private entities in the smaller counties. They are oftentimes working the front line. They're at the counter to assist litigants who might need some direction on a form. They can assist in calculating child support. They can assist in explaining legal terms, describing basic court procedures, how a service works, et cetera. And they can actually review the completed forms, and occasionally they will attend pro se hearings. But they are not offering advice per se. They are more providing the basic information. They listen to the litigant, and then they try to discern what it is they are looking for in terms of reform and provide that information. That has been very helpful to us. These are non-attorneys. They cannot do some of the basic things that a LLLT can do, however. LLLT, for example, can advise the client of the significance of the selected forms to the client's case. They can review the documents or the exhibits that the client has received from the opposing side. And they can also provide legal research if there are issues that are more broad than that originally presented. So, and those are things our facilitator can't do. And so in that sense, it fills a gap for us. We also recently developed, and we stole this idea from our friends in California, what are called early resolution case managers. And these individuals are attorneys, and so they bring a little more nuanced knowledge sometimes. And the benefit to us is they can perform mediations between the parties. And that has been a great service to us. They're also more available to the judicial officer in court. So for example, if Judge Trickey were to say, you know, this form needs a little more work, he can turn to what we call ERCMs, or early resolution case manager, and they can go off and come back 20 minutes and kind of keep that case going. And it's been a real benefit to us. And so what's going to be real interesting for me is to see how the LLLTs kind of fit into this mix of facilitators and early resolution case managers. But my hope is, and my optimism is, that it'll actually lessen the workload for us, that some individuals who might not be able to afford an attorney can afford a LLLT. They would be able to get that service before they come to the court, and they would have that upfront representation that we now don't have. And that would allow us to meet the needs of our growing family law litigant population, or to deploy those resources to other areas of self-service in the court. So I started out as quite a skeptic, and I'm becoming more optimistic, and I think a couple years from now, after we've had some experience, after they've started their work in 2015, hopefully we'll be able to give a good report back to you in about 24 more months. So I think now we want to open it up for questions.
Yeah, and before, I just want to quickly answer a couple of questions that came up in your remarks. About reaching out to the trial court, that's part of we've sort of triaged this process, and part of it is, we got to do these things first, but we really recognize the need to reach out to the courts, the community, to the bar, and make sure that everybody understands what these are and what they're not. The second one was the concern about the scope and people wandering beyond. Interesting part of the curriculum that was created for, particularly in the practice area, the curriculum includes not only what they're authorized to do, but it provides them with education in areas that they're not authorized, so that they do understand, here's the bright line, do not go over the line, these are things you are not trained to do. And the third thing is, and this is a huge and important thing, and it sort of follows up with what Paul ended up with. In a few years, we can look back and see how it worked. I felt from the very get-go, this program needs to be evaluated independently, and we just can't say, oh yeah, pat ourselves on the back and we think we did a good job. So we've been contacted by a foundation in Washington, D.C. who has a great interest in access to justice, and they really want to help us evaluate this program over the next 2 to 3 years so that we can look at it and say, we could do this better, or we did this well, it's replicable in other jurisdictions. So those are things that I think, hopefully, we're trying to keep our eye on. Now, questions?
So first I want to commend you for the care you've taken in putting together this program. But since this program specifically is to address access to justice issues, what discussions have you had about regulating fees that the LLLTs can charge so that it addresses those issues?
Oh yeah, we've had a lot of discussions about that from the very, very beginning. And of course, the first thing that confronts us sounds like antitrust. When I began practicing law, we had a fee schedule. And in fact, I ran across it the other day, and it's not going to happen. We believe there is a huge market for these services. I mean, LegalZoom brings in millions and millions and millions of dollars just selling forms. And we think the marketplace will regulate that price. I think LLLTs going into this understand why they were authorized and who their target market is. But for example, I don't think I as a consumer am going to go to a lawyer who charges X number of dollars or a LLLT who charges the same. And I'm going to go to the lawyer. So the LLLT necessarily is going to charge less. And I think they'll look at the marketplace and probably look at what paralegals and LLLTs are being billed out in firms. That would be one of the business models. And I think they'll also look at LegalZoom and the services that are being charged there. I don't know. It remains to be seen. It is a bit of a leap of faith, but I don't think they're going to be charging the same as lawyers and running them out of business because they don't have the same breadth of license.
No, take another.
There was one, I think, one here and one way in the back, I think.
Put on my track shoes.
Maybe you said it, maybe I missed it. Are you expecting that law firms will have LLLTs within them?
Good question. We've given a lot of thought to what would the business models be. One of the unique things about LLLTs is that they can be freestanding. They do not have to operate under the supervision and guidance of the lawyer, so they can be freestanding, which I think some entrepreneurial ones will. And I think as we roll out other practice areas and they can piece together 2 or 3 practice areas, it's sort of like me as a small town sole practitioner. I do 3 or 4 things, and I think I do them well. I don't need to do all of them, but maybe it's helpful for me to do that many to make my practice viable. I think the same as a freestanding LLLT will be true. I also think entrepreneurial lawyers are going to say, this is a segment of the market I can address that I can't with my present hourly rate. And so I think entrepreneurial lawyers will say, I'll bring in 2 or 3 LLLTs and assist, the general flow of business into the firm. And there's one way in the back.
In your study of developing the LLLT program, have you been looking at the medical profession and the way it's segmented for guidance or tips as what not to do?
Well, yeah, very good question. Early on, as I said, we looked for the model around the country and went, gee, we don't see one quite like. Well, it only took us a couple of years, and we looked around the room, and the doctors did this about 30 years ago, and they did it pretty successfully. And I think they did it with the same amount of resistance. I think, but I'm not a doctor, but looking from the outside and being a consumer, I think it works pretty well. And so I think, the fears that may exist of, gee, this will never happen. We're lawyers. We're too highly trained. I just don't believe that's going to happen. I think you just look across the room at doctors and say, well, it's working pretty well there. There was one in the back.
I too want to commend you on what you've done.
Thank you.
I'm a big pro se advocate, but I'm going to give some kudos to where I'm from in Tampa, Florida. When a pro se litigant files a case, both parties are pro se, they're immediately given a case manager that works with them from day one to the end when they're divorced. We also have a forms clinic that is staffed by Stetson Law students. We have we call her a free lawyer that's there every day. If you get there, you sign up. The Hispanic Bar Association helps us with the interpreters when interpreters are needed. We have mandatory mediation, which helps out a lot. We also have child support guidelines that we have to follow. I don't know if you do in the state of Washington. And I don't think there can be enough help for these parties. We have a website you can go to where you can download all the forms. They're in English and in Spanish. So, but I think you've done a great job, and I think it's kudos to the pro se parties.
Yeah. I would say I couldn't agree more in the laudable efforts in your jurisdiction and others. I've maintained all along this probably is not the solution. I don't think there is a singular solution, and that's why in my vernacular, you need as many tools in the toolbox as you can. It's a huge problem, and I think every way we can approach it is what we should be doing. And I don't think any one's going to solve the problem, but maybe collectively someday they all will. How are we doing time-wise? Okay.
Can you envision an triple LT, at working as a civil clerk in the clerk's office of the court, employed in that regard?
I don't know why they couldn't. I mean, I think it would be a skill that would enhance their ability to do their job. There would certainly be no prohibition for that.
Okay, and I ask because, they come to the civil clerks, and we're not allowed to give them any instruction, but if we had a triple LT, then they could be assisted in navigating the waters.
I didn't understand your question quite in that way. I think the clerks are going to be restricted by the job description, whether the lawyers triple LTs are not trained in either field.
So it might be a position that would be added to the clerk's office?
I could see that. Probably not unlike courthouse facilitators.
I think it's more likely it could be added to the court side of the house. The clerk's office is very prescribed via our statutes in terms of what they may or may not do, and that may have a little more leeway on the court side.
One thing to point out real quick is in Washington State, the clerks are frequently members of the executive branch. They're separate and apart from the court system. And in many counties in Washington, they're independently elected officials. And so just so you know, because we just couldn't say, clerk, add more of these, because many of the clerks would say, well, we have our own process. So.
My sense is that might also be a way to regulate the cost, because you would pay them a salary if they were employees of the court, kind of similar to your idea about in a law firm, but they probably wouldn't feel as much like stepchildren in the court as they might in a law firm. And that would regulate the price because they would have a salary.
And I would just supplement the comment by saying, we met with so much resistance 5-6 years ago, and it's really surprising and encouraging that people come to us every month and say, could this rule be applied to this area or this area? And I was invited to speak to the Prosecuting Attorneys Association in early May, and they were very interested in having triple LTs assist them representing unrepresented parents who are being assessed with child support. You know, they feel badly that this is not a level playing field, and frankly, when we developed the rule, never thought of that as an application, but certainly a very helpful way perhaps for the system to be assisted and for citizens to be assisted.
Sorry. I don't usually need a mic. The parallel's already been drawn to the physician's assistant nurse practitioner, but for them, both experiential and educational requirements are pretty rigorous. I mean, you can go down to the midwife level and say the education and experience are pretty substantial. It's much more than a 2-year degree or 45 credit hours. Have you given some thought about that? Is that if this gets into the advice or counsel area, that this will require a lot more experience, a lot more education to get this kind of a certification?
Yeah, you know, we certainly want to make sure these people are qualified, and if expanding the scope by appearing in court and negotiating in the minds of the educators, really, the people will turn to say they're being authorized to do this, what education do they need to have in place to be qualified to be able to deliver those services? We think that's why you know, having the 3,000 hours, which is far more than we as law grads ever have when we hit the streets, is helpful. Is it enough? I don't know. It's more than what has been expected in the past. And again, we're going to be tweaking this program as we move along, and especially as we get the results from the evaluation to see, are we really doing as much as we could, or could we do an even better job?
I'll say that as a clerk of court, thank you, because I think this is a great idea. It would greatly help us.
Good. Great. Good.
Yeah, and I echo that. I think it would greatly help us. However, as a clerk of the court, I would adamantly resist that being a function of the clerk of the court. I think that's, that there are legal implications there that I just don't believe an elected official should assume.
And I want to point out, each and every one of these authorizations, these practice areas, it's all approved by the state Supreme Court. I mean, we're just not sitting in a room, 13 of us coming up with crazy ideas. They may be crazy at first, but we send them down to the Supreme Court and say, are we really crazy, or is this a great idea?
I want to echo your concern. When lawyers today are on the staff of the court, the lawyer cannot give legal advice to parties. That violates the court's requirement to remain impartial. So that would also apply to the LLLT. The LLLT on a court staff would be constrained to provide information and can't go over in the advice area. Steve, I wanted to ask you the extent to which your board and committee has been also working on unbundled service delivery, getting the Washington Bar to fully embrace limited scope representation.
To be honest, we haven't done any of that. I think it's something that we should do. We've been running so hard the last 18 months just trying to get the rule implemented. And I mentioned a to-do list and kind of triaging things and, you know, reaching out to the public is one of these things that's down here, but something we really know we need to do. And that's something I think, you know, how do we interface with courthouse facilitators? You know, is there a way we can better interact to make this all work better? And the same thing about unbundled legal services and, you know, just freeing up the system so it's more accessible and more affordable.
I'm curious what state of Washington has licensed paralegals, and if so, like, is this kind of? It seems like it's a paralegal, but just a way to license them.
No, the state of Washington does not license paralegals. We have limited license practice officers, LPOs, limited practice officers, who do real estate closings. You know, and paralegals can take national exams, gain some certification. You know, we acknowledge that the core education is sort of the first stepping stone for LLLTs and is very similar to the paralegal program, but we feel that this is maybe paralegal on steroids. I mean, from the standpoint that, you know, they're licensed, they're regulated, they have to take an exam, and they're subject to the same standard of care as lawyers, same rules of professional conduct. So I think to say they're kind of the same is true in a sense, in a very fundamental, generic sense, but different in terms of how they're regulated and the scope of service they can provide to the public. Do you guys want to make concluding? Well, on behalf of the panel, let's get the heck out of here. Huh?